6:15, we're going to call this meeting of the Board of Adjustment to order, and that
He doesn't.
we'll have Rick present first agenda, family agenda.
First thing on the agenda is a public or variance for Tom Brown and Kathleen Olson. The application was received from the following persons for a variance of setback requirements: Thomas Brown, Kathleen Olson. They're part of the southeast quarter, the southwest quarter, the northwest quarter, the southwest quarter line in sections 13, Township 103, Range 5 West. Union Township. A variance of 22 feet to meet the required 25-foot setback from the toe of the bluff to build a deck. The hearing on this application will be held at the Houston County Justice Center basement, City of Caledonia, Minnesota 55921 at 6:15 p.m. on Tuesday, September 22nd, 2015. Houston County Board of Adjustment by Rick Frank, Building Administration. Advertised September 9th, 2015. Yes. Mr. Brown and Ms. Olson here they live on 7175 County 20 in Caledonia. They're seeking a variance of 22 feet from the required 25-foot setback. The purpose of the variance is to build a deck, a 20 by 20, a 12 by 20 wood deck, and it's attached to their home. Zoning permit 3837 was issued to build a single-family home, was issued in July of 2011. There was no deck noted on the original building permit or soil erosion control plan. The construction of the Browns' home was completed in 2014, and they opted to delay building a deck until the ground had the chance to settle. Union Township Board and joining property owners were notified, and I have not received any inquiries, pros or cons on the application.
Do you have any more to add to this, or any thoughts?
Well, the one thing I would like to add is that as our house is built, right now the only exit we have is through the basement. So if we ever did have a fire in the basement, we have to jump 4 foot open, out the door. And that's one we'd like to have that for more of a safety thing. That's awful, but
We had worked pretty diligently with soil and erosion and with the zoning department to ensure that we met all of the setback requirements and so forth. And as we embarked on this project, and the property is pretty challenging. There's quite a slope there, and so we actually, Bob Scanlon and Dave Walter flagged the exact location of where our house could be located for us, and so we really tried to be in compliance with all the zoning requirements, setback from the road and bluff and so on and so forth. When we built the house, the deck was actually part of our building plans that we submitted when we asked for a building permit. But we didn't understand that the soil and erosion plan, which had been developed earlier on in the whole project, also needed to be modified to reflect the addition of the deck on the back. So actually, in response to the suggestions that were made to us, we built the home with the walkout basement to, again, try to minimize any movement of soil and to take advantage of the natural water flows around the house. As my husband said, that now means that the main level of our home is kind of on above the top under the garage and so forth. If we didn't have a fire in our basement, our only exit would be through the patio doors and the deck that we originally proposed to build. We held off on that as stated to let the ground settle. And so we were a little surprised when we applied for the permit to add on the deck to learn that there was a variance required for the deck itself. We didn't understand that was a structure and that was considered part of the structure. But when we built the house, we worked very hard to minimize the disruption of the natural slope and water flow of the property so that we would not have erosion problems. And it's our hope that with the hardship of, I guess, the topography and the setback variance requirements, as well as which drove the design of our house, that we could have that deck built, which would allow for a safer exit, as my husband said, in the event of a fire or some emergency that prevents us from exiting out the road level. The deck itself would be a wooden deck with 4 cemented posts in the ground. And we don't believe, and nor did Dave at the time, Walter, that would have any impact in terms of erosion or sloughing of the bluff. And it's our understanding that one of the main reasons for the setback requirements is to preserve the bluff land and the quality of the property, and that's been our goal as well. So we would just respectfully request that you consider our application for the I'd be happy to answer any questions that you might have about how we landed to this place and what we would propose to do moving forward.
I can see where your house is built down there, and it is a challenging place to build. That I
Yes.
agree with that. My dad was a carpenter for 40 years and that stuff. When I personally built the house there at my age and mowed the lawn as steep as it is, probably not.
We invested in a new lawn here, our used one tractor, yes, for the lawn.
Most times when we have these rough-land issues, it's dropping away from the house or something instead of you going toward the rough and stuff. And, you've got your plan or the way it worked out, and that water would run underneath the tractor. That's not going to hurt anybody. And the hillside there, it looks like it's seeded down very well, it's taken very well.
Yes.
Okay, moving on.
Yeah, no problems.
Questions here? Right, on these criteria for that?
Sure.
I should ask if there's anybody in the audience that would like to speak on this hearing, this matter. If there is none, then will that read the criteria?
Area variance standards, practical difficulties. Number 1, is there a substantial variation in relation to the requirement? Number 2, will the variance have a negative effect on governmental services? Number 3, will the variance affect a substantial change in the character of the neighborhood, or will there be a substantial detriment to neighboring properties? 4, can the practical difficulty be alleviated by a feasible method other than a variance? 4, how did the practical difficulty occur? Did the landlord create a need for the variance? And 6, in light of all the above factors, will allowing the variance serve the interest of justice?
Anyone have any problem with these criteria? I will ask for a motion to either approve or deny this variance.
I move to grant the variance.
I'll second. All those in favor signify by saying aye.
Aye.
And I think we should give some reasons why we are approving this variance. Something new, we have to have a reason, and we are granting it because of practical difficulties or whatever you want to weigh in with it.
What Chairperson Cruz is indicating is that now that you have set up the framework and you've granted this, you just have to give some reasons. They're all in here in your head. You just need to say it out orally so we can make a record. Because someday if someone would ever challenge this, there has to be, this is the record you're making for the court. And so otherwise, it would just be arbitrary. So you just have to give some reasons. You heard these people speak, you've taken in, you've asked some questions. You just need to cite those now why you think this is a good thing to grant.
Well, I think
it's good because they work with the soil conservation, they've got a water plan, and they're not, you shouldn't be losing any soil, so I think they've got a good soil, and working with the conservation, that's a pretty good reason.
That's perfect.
And they also mentioned the safety issue as far as having another exit out of the house.
And it was a very challenging site, and I think it's the best solution for the site.
That's fine, thank you.
I'll call the motion, I guess I did call the motion. And this variance is approved.
Thank you very much.
I'll make a motion to approve
Quick question, do you guys have a microphone up there?
Right here.
Oh, is it on?
I think so.
You have to place the microphone in front of you for it to pick up. Directly. Oh, those things are microphones? Yeah. I was wondering.
It is. How's that?
All right,
Better?
that is much better.
I guess it's better.
Thank you.
Yeah, they would have been. I'll make a motion to approve last meeting minutes. Is there a second to the approval of the last minutes of the last meeting?
I'll second that motion.
Motion been made, and second to approve the minutes. All those in favor, signify by saying aye. Aye. Negative, say nay. Minutes are approved. Six 6:30, and that we're going to call the zoning appeal hearing. Next, people.
This is a continuation from last meeting we had in regard to a zoning appeal. An application was received from Fred and Ricky Krugel. Of Crooked Creek Township. As you know, last meeting, there was information on what happened here. Let's give a little history. Was that the staff had made a determination based on information we had that there was not a registered quarry on property that that Fred and Vicki had here down in Crooked Creek Township, we did go through a lot of information, mapping, different things that, to try to see if there was a quarry on the site prior to, or including the year 1972, when the county did register a lot of quarries in the county. As we were going through with Fred and trying to look for information there that staff could not find, we had at that time made the determination that that it indeed was not a registered quarry on our registration list, and therefore it was not considered a mine at the time. Mr. Kruko has since been, has appealed that decision that was made by staff, and he had asked that there was, he was generated additional information as he had for a couple of, I think, of affidavits that he had in last meeting, and subsequent, I think we have added additional affidavits that you have as far as your packet there, that this mine was indeed, was used prior to 1972 and including 72 and all the way up to the present, that it has been an active, mine. The board had turned around and, like I say, last month, or last meeting we had, they tabled it, and since went down to the site, and you had a chance to walk the site and review location of the site compared to see the activity that has taken place down there over the course of the years. I've also had correspondence from Mr. Tom Hovey from the DNR. He's had a chance to view the information that was requested him prior to my talking to him. Even he had inquiries as far as the location of this mine compared to where the stream is. And I think we've included an email that within that saying that the DNR has no jurisdiction on this stream, that the trout stream setbacks that are in place at the state level do not apply to this because it's the trout stream designation actually stops, he said, 1.7 miles upstream. But he did note this is still public waters of the state. And as I say, the trout stream setbacks that the state is enforcing into sand mines at this point do not apply to this pit. As I mentioned here earlier, also that we do have additional affidavits that has been handed to the county this morning. One being from Nancy Welcher, and then also one from Fred Kruko himself. The Crooked Creek Township Board and Joint Property Owners were notified. There were a couple of inquiries to the zoning office in regard to the application. I did talk to a couple of the local residents, and their inquiries were more of where it was at and what are they actually asking for in the mine and the process and everything that we're going through to understand what they want to happen. So that's all I have.
All right, Tim, Fred, do you have anything more to add?
Well, I guess just to follow up, and as we noted earlier, at the earlier hearing, there was no formal procedure back when the mines were registered. I mean, it was quite informal. There weren't formal forums. There wasn't a confirmation sent out or a public notice. So they believe that this was one of a number of properties that they had registered and operated as registered. Now, Mr. Frank alluded to the aerials, and there's a couple of aerials. The aerial, I don't know what date the aerials are that you have there, but we don't have an aerial for 72. We're right at the time, right before the registration. We had one a number of years before. And then we have one after that, which does show it. And we have affidavits from Mr. Colmeyer, who's on the Crooked Creek Township, saying that this was an active pit back in the 60s. On board, Reuben Schrader, who worked in the pit. We have Nancy, we filed an affidavit of Nancy Welsh, who was a bookkeeper at Krugel Bonanza Green, saying that material and buildings and things were done for sand out of it during this time frame. And then Fred has presented his evidence verbally before, that we also had put an affidavit for him. So we think it's overwhelmingly showing that this has been operated as a pit. I mean, it's been a construction sand pit. The sand has been used for projects like Reno and water for grip construction and Krugel and road projects for the county and township area. We think that the evidence is overwhelming that this has been an active pit, and if there's the records aren't complete or whatever happened back when, unfortunate that it wasn't very formally done back in the early 70s. So anyway, that's where we're at. We don't think they should be prejudiced by that. So we would ask that you grant our request.
Any questions for Tim and Fred at this time? All right, at this time, I'll open it up to the audience and that stuff. And if you speak on this, you stand up and say your name, and if possible, come up where the microphone is so we can hear you.
Michael Fields, Winnebago Township. You might be in a situation where you're going to have to carry this over to the next Board of Adjustment meeting, because it seems to me that the only way to be sure that this line has been in continuous operation for as long as they say, and you're saying that they're selling this stuff, is to check with the tax assessor. Because if he's selling this stuff, there has to be a tax record of what it was he sold and who he sold it to and how often the stuff was being sold. So the only way to really be sure if the mine has been in continuous operation is to check with the tax assessor and be sure that all the taxes have been paid properly and that the mine has been in continuous operation. So again, I said you probably might need to carry this over to the next Board of Adjustment meeting. Thank you.
Is there anyone else?
Bruce Hugo from Caledonia. So you went out last Tuesday and you looked at the mine. What did you find?
Found sand pit. Where sand had been taken out for many years, the way it looked.
Where was the sand pit in relationship to Crooked Creek? How many feet away?
Doesn't make any difference. Because the setbacks do not allow.
In section 9, non-conforming uses, it says, non-conforming uses may be continued. It is the intent of this ordinance to permit these non-conforming uses or structures to continue until they are removed, but not to encourage their survival. Such uses as declared by this ordinance to be incompatible with permitted uses in the districts involved. It is further the intent of this ordinance that non-conformities, which is what this mine is, that is to say it does not conform to the conditional use permit of mining in section 27, that nonconformity shall not be enlarged upon, nor expanded, nor extended, nor to be used as grounds for adding other structures, which would be such as maybe a scale house, things of that nature. If there were 130 other people back in 1972 that went through the bother of telling the county that they have a pit on their property, why didn't Mr. Krukow do the same? Not only that, he's had 43 years to get his name on something. When I went to college and I couldn't turn my term paper in time, tough luck, Bruce. And as to the 100 feet, it doesn't make any difference. What? What? It doesn't make any difference? What is this book all about? People told me in other commission meetings that I had to read this in order to talk to you people. I have read it. A non-conforming mind needs to conform to the law. Now, they may not have to have a CUP, but they still need to follow the regulations of the mining ordinance. They need a reclamation plan, they need an operations plan, they need the setback requirements. They can't operate within 100 feet of public water. Where did they get this exemption? Why did they think that non-conformity means they can do anything they want? That is not what the law says here.
Jay Squire says the same thing.
Thank you.
Brian Bencourt, Ukiah Township. I think, unfortunately for Mr. Krukow, this whole issue is coming to a head, and it's going to affect him. And the county is at a point where they have to decide if non-conforming mines have to abide by the law, like the 100-foot setback on streets. Just because a mine would be non-conforming, we certainly would not think that they're allowed to pollute Trout Street. Why would non-conforming mines be allowed to do things that permitted mines would not? That's illogical. If anything, they should be held to a higher standard. We cannot have no standard simply because a mine is non-conforming. And it seems to me that at the very minimum, there's a lot of questions here. I think that's safe to say. At the very minimum, there's a lot of controversy here. Now, why wouldn't he be required to get a CUP? Because if the mine conforms to the law, he can get a CUP. If it does not, he should not be allowed to operate it as a non-conforming mine. No one is saying he can't mine, but he should have to get a permit to mine because he has to conform with the law, and the law says that he has to be 100 feet from Charles Street and so on. And that's even if you grant that this mine was operating continuously since 1962, which is entirely not clear. For example, could we look back on Google Earth and see periods of inactivity where plants are grown in the bottom of the mine or so on, or has this mine continuously been taxed at the commercial rate, or do we have receipts for the last 7 years showing operation? I think the burden of proof here does fall on the mine owner, not on the public.
Anyone else?
Ron Parks, the Caledonia Township. I just wonder why Mr. Krukow is insisting on having it as a non-conforming mine. The only difference between a non-conforming mine and a permitted mine is the CUP. They still have to follow all the rules. I believe Mr. Young would back that up, that a non-conforming mine can continue operation without getting a CUP, but has to still follow the rules that everyone else has to follow. You might want to ask him.
Tim, you want to add
Well,
something?
I guess the issue here is not many of the issues that they're attempting to interject in here. The issue is whether there's been an operating line and was registered, but it's omitted on the records. And we're showing that it was. And that's the issue here from our point of view. And the rest of this is smoke and mirrors that you've all heard many times before.
My name is Sharon Beck, and I lived down there my whole life. And I only remember one summer when there's a whole lot of activity, and otherwise, I haven't seen any for the last 40 years or so. It's been pasture land. Thank you.
Jeremy Sugno.
By the microphone.
Oh, by the way. My name is Jeremy Sugno, Leo Greaser's grandson, Sharon's my mother. My entire life up until 8 or 10 years ago, I was under the impression that my grandfather actually owned that land, because there was nobody else I'd ever seen in there. I know the no trespassing signs went up, was it 4 or 5 years ago? I believe they put them up, and that was right after my grandfather went around and put a new fence around the property because his cattle were pasturing it. In my life until, I think 2 or 3 years ago, I've never seen a truck or anything happen in there.
Gretchen Buckland, Crescent. How can it be a recorded mine if there's no record of it? Registered mine, if there's no record of it.
Yeah, but it's not registered, right?
And you should have 7 years of taxes to back it up, because that's needed for the IRS, yeah. Thank you.
Do you have any plans?
My understanding is that the issue, my understanding the issue for the adjustment is having an operation has been discontinued. They have provided evidence to that effect at this point. That's for you to weigh as finders of fact. As far as the registration or non-registration, my understanding of that is there's no requirement on zoning code to have registration. The only thing for non-conforming mines, back in '72, there was a call, newspaper ad that asked for persons to come in and put their name on a register for a meeting that was to occur, I believe it was in November. It did not occur. And so the reason behind the registration, I really think, is a moot point at this point. It's more, did they meet the standard for your benefit regarding the occupation and mining activities during the period they say it did occur. If it did, then they have met that standard. If not, then they haven't. And that they provided affidavits from a number of individuals, and if you feel that's sufficient, then you do.
Yeah? You talk once. I think.
If Mr. Krukow has obtained affidavits to the effect that mining operations have been in continuation for over 43 years, but the two people that just spoke who lived in that area are basically saying the antithesis, but there is no affidavit, are they discounted and they came here by nothing? Or is their word still honored by you? Is only the written word honored, or is the vocal word honored as well?
We're listening. What? We're listening.
No, that's not what I said. I said, do you honor their statement, even though it's not an affidavit? Does it have the same weight as an affidavit?
A lawyer would have to answer that question. And
Well, then it seems as if you can't make a determination until you get some kind of
We
determination.
can't do it.
Mr. Chairman, you're asking me that question?
Sam, did you get a microphone, give a mic there?
I do not. Are you asking me that question, Mr. Chairman?
Yes.
That's all evidence that there's an affidavit in front of you. You have these people here, you want to ask them further questions. You would, as opposed to having the actual person here that you cannot question from this kind of affidavit, you can weigh that evidence accordingly. But that's you are finders of fact. And if you do make a decision here, just like in the previous matter, you have to give the reasons behind it. And one of the issues that you would have to decide here, in this case specifically, would be, it seems to be credibility. And that's for you as finders of fact to make that decision.
I'm Frank Krupa, and in regards to Jeremy's statement that it hasn't been, Jeremy got sand this summer. He's gotten sand in the past.
This summer, I'm sorry.
Yeah, but you have gotten sand in the past.
This summer.
Well, this summer and in the past. So, activity in the quarry, whether it's, and as far as Sharon, is it Sharon? Yeah. She lives, I believe, to the west of the site. And obviously the driveway there can be activity going to the east of the site that she probably wouldn't see. Activity in the site, whether you're cleaning things up, whether sand's going out, it's still activity. So there's always been activity there. I frequented this mine all the time. And I think you, after your visit, you probably can see that. Thank you.
You spoke before?
This would be a different subject.
Okay.
Situation that has been evolving. Michael Fields, Winnebago Township.
Mike, hold up, we can't hear you.
Mike Fields, Winnebago Township. We don't know what these affidavits say. Do they say that the mine has been in continuous operation since 1972, or do they just say it's been used, I've seen it been used? If it does say that it's been in continuous operation since 1972, then somebody's lying. Are you going to say that these people who testified are lying then, or are the people that issued the affidavits, are they lying? Also, the county's own land use attorney, Jay Squires, says this whole notion of a registered mine, and Jay Squires himself does use air quotes when he says registered mine. It's a complete fiction. It's a completely made-up rule. There is no such thing as a registered mine.
Okay. Any discussion from the board? No? You want to give them criteria for the zoning appeal?
Criteria for granting a zoning appeal. Name of applicant, Fred Kruko. Today's date is September 22nd, 2015. The Board of Adjustment shall not grant an appeal unless they find the following facts at the hearing where the applicant shall present a statement and evidence in such forms as Board of Adjustments may require. Number one, that there are special circumstances or conditions affecting the land, buildings, or use referred to in the appeal that do not generally or apply generally to other property. Two, that the granting of the application will not materially adversely affect the health or safety of persons residing or working in the area adjacent to the property of the applicant and will not be materially detrimental to the public welfare of the injurious to property or improvements in the area adjacent to the property of the applicant.
Any discussion from the board? Then I will ask for a motion either to approve or deny this zoning appeal.
I'll make a motion because of the facts that we have gathered and the affidavits that we have looked at, and they've been from different times and different years. And all this deed and all that, I guess I would make a motion to overturn the zoning staff.
Wow. To grant the appeal?
I grant their appeal.
Wow. All right, is there a second to this motion?
I'll second that motion.
All right, motion been made and second to grant this zoning appeal, and any further discussion? I'll call the motion, all those in favor, signify by saying aye.
Aye.
Aye. Appeal.
Wow.
Thanks for
Shameless.
Shameless.
Really shameless.
Motion been made to adjourn. Give a second. And all in favor, signify by saying aye. Aye. Adjourned.